Evidence last chapter. Chapter 7. Offer of evidence and trial objections, Rule 132. The provisions relevant to this chapter are reproduced as follows, Section 34. Offer of evidence. The court shall consider no evidence which has not been formally offered. The purpose for which the evidence is offered must be specified. Section 35. When to make offer. As regards the testimony of a witness, the offer must be made at the time the witness is called to testify. Documentary and object evidence shall be offered after the presentation of a party's testimonial evidence. Such offer shall be done orally unless allowed by the court to be done in writing. Section 36. Objection. Objection to evidence offered orally must be made immediately after the offer is made. Objection to a question propounded in the course of the oral examination of a witness shall be made as soon as the grounds therefore shall become reasonably apparent. An offer of evidence in writing shall be objected to within 3 days after notice of the offer unless a different period is allowed by the court. In any case, the grounds for the objections must be specified. Section 37. When repetition of objection unnecessary. When it becomes reasonably apparent in the course of the examination of a witness that the questions being propounded are of the same class as those to which objection has been made, whether such objection was sustained or overruled, it shall not be necessary to repeat the objection, it being sufficient for the adverse party to record his continuing objection to such class of questions. Section 38. Ruling. The ruling of the court must be given immediately after the objection is made, unless the court desires to take a reasonable time to inform itself on the question presented, but the ruling shall always be made during the trial and at such time as will give the party against whom it is made an opportunity to meet the situation presented by the ruling. The reason for sustaining or overruling an objection need not be stated. However, if the objection is based on 2 or more grounds, a ruling sustaining the objection on one or some of them must specify the ground or grounds relied upon. Section 39. Striking out an answer. Should a witness answer the question before the adverse party had the opportunity to voice fully its objection to the same, and such objection is found to be meritorious, the court shall sustain the objection and order the answer given to be stricken off the record. On proper motion, the court may also order the striking out of answers which are incompetent, irrelevant, or otherwise improper. Section 40. Tender of excluded evidence. If documents or things offered in evidence are excluded by the court, the offerer may have the same attached to or made part of the record. If the evidence excluded is oral, the offerer may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. Importance of offer of evidence, Bar 2003, 2012. 1. An evidence must be formally offered. Under the rules of court, the court shall consider no evidence which has not been formally offered, Section 34 Rule 132, Rules of Court. 2. The offer of evidence is necessary because it is the duty of the court to rest its findings of fact and judgment only and strictly upon the evidence offered by the parties. Aludos v. Suerte, 673 SCRA 413, 425, June 18, 2012. Thus, in Dizon v. Court of Tax Appeals, 553 SCRA 111, it was ruled that no evidentiary value can be given the pieces of evidence submitted by the beer, since they were not formally offered. This is the rule under Sec. 34 of Rule 132 of the Rules of Court. 3. In Spouses Tan v. Republic, 573 SCRA 89, the court sustained the Court of Appeals which refused to consider a document submitted for the first time by the petitioners when the same was attached to their motion for reconsideration of the decision of the Court of Appeals. In sustaining the appellate court, the Supreme Court reiterated the rule in Sec. 34 of Rule 132 that the court shall consider no evidence which has not been formally offered. The document should have been offered during the trial in the regional trial court. Marking of a document, not a formal offer. 1. A document, or any article for that matter, is not evidence when it is simply marked for identification, it must be formally offered, and the opposing counsel given an opportunity to object to it or cross-examine the witness called upon to prove or identify it. A formal offer is necessary since judges are required to base their findings of fact and judgment only, and strictly, upon the evidence offered by the parties at the trial. The appellate court will have difficulty reviewing documents not previously scrutinized by the court below. The pertinent provisions of the revised Rules of Court, on the inclusion on appeal of documentary evidence or exhibits in the records, cannot be stretched as to include such pleadings or documents not offered at the hearing of the case. Candido v. Court of Appeals, 253 SCRA 78. 2. There is a distinction between identification of a documentary evidence and its formal offer as an exhibit. The first is done in the course of the trial and is accompanied by the marking of the evidence as an exhibit, while the second is done only when the party rests its case. Dizon v. Court of Tax Appeals, 553 SCRA 111 citing VDA, de Oñate v. Court of Appeals, 250 SCRA 283, and Interpacific Transit, Inc. v. Aviles, 186 SCRA 385. When formal offer of evidence is not required. 1. A formal offer of evidence is not required in certain cases, thus, in a summary proceeding, because it is a proceeding where there is no full-blown trial. B. Documents judicially admitted or taken judicial notice of. C. Documents, affidavits and depositions used in rendering a summary judgment. D. Documents or affidavits used in deciding quasi-judicial or administrative cases. Bantolino v. Coca-Cola Bottlers, Inc., 403 SCRA 699, or E. Lost objects previously marked, identified, described in the record, and testified to by witnesses who had been subjects of cross-examination in respect to said objects. Tabuena v. Court of Appeals, 196 SCRA 650, People v. Napit A. 179 SCRA 403. 2. There were instances, however, when the court allowed the admission of evidence not formally offered, as in People v. Napit A. Supra, citing People v. Mate, 103 SCRA 484, where evidence not formally offered was held to be allowable provided certain requirements are present. A. The evidence must have been duly identified by testimony duly recorded, and b. The same must have been incorporated in the records of the case. See also Medina v. People, cr. Number 182648, June 17, 2015. 3. In People v. Libnow, 395 SCRA 407, evidence of the prosecution in a crime involving a violation of the Dangerous Drugs Act were considered by the court even without their having been formally offered because the evidence were properly identified by testimony duly recorded and incorporated in the records of the case. The counsel for the accused also cross-examined the witnesses testifying on the evidence. When evidence is offered by petitioner but not by respondent. In one case, certain delivery receipts and sales invoices did not form part of respondent's formal offer of evidence, but the same formed part of petitioner's formal offer of evidence. Petitioner insisted that since the said documents did not form part of the evidence formally offered by respondent, the trial court and the Court of Appeals had no legal basis to award interest and damages in his favor. The Supreme Court held that no error could be ascribed to the lower courts because the delivery receipts and sales invoices were, nevertheless, formally offered by petitioner in evidence. Hence, the documents may be considered by the courts below. Titan Construction Company v. Unifield Enterprises, Inc., 517 SCRA 180. When evidence is to be offered. 1. As to when the offer of evidence is made depends upon the nature of the evidence. A. As regards the testimony of the witness, the offer is to be made at the time the witness is called to testify. Sec. 35 Rule 132, Rules of Court. B. As regards documentary and object evidence, they are to be offered after the presentation of a party's testimonial evidence. The offer is orally made unless allowed by the court to be in writing. Sec. 35 Rule 132, Rules of Court. 2. The provisions of the Rules of Court, as stated above, give a simple rule as to when an evidence is to be offered. Hence, the presentation of a documentary or object evidence for marking and identification during the course of the trial is not the offer contemplated in the rules. Failure to object to the evidence at this time should not be construed as a waiver of the objection to the evidence. 3. A relatively well-known criminal case, Macassari v. People, 291 SCRA 154, is instructive as to when an objection to a documentary evidence need be made. It, once and for all, reinforces what has already been made clear by the Rules of Court, that objections to a documentary evidence shall be made after it is offered and the offer of such evidence shall be made after the presentation of a party's testimonial evidence. The case involves a certain Macassari and two others who were accused of murder. During the course of the trial, the prosecution introduced, among others, two documents. One was an extrajudicial confession by one of the accused admitting his participation in the crime and implicating the others. The other document was the transcript of stenographic notes taken during the preliminary investigation of the case. At the time the documents were introduced for marking and identification, the accused interposed no objection to the evidence. When they were, however, offered at the close of the prosecution's presentation of evidence, the accused objected to the admissibility of the documents on the ground that the documents were made without the assistance of counsel. The trial court sustained the objections and declared the documents inadmissible. However, the Court of Appeals declared the two documents admissible and ordered their admission by the trial court. In so holding, the Court of Appeals considered the failure of the defense to object to the documents when they were introduced for marking and identification as a waiver of their objection. In reversing the Court of Appeals and reinstating the order of the trial court excluding the documents, the Supreme Court ruled that a party is not deemed to have waived objection to admissibility of documents by his failure to object to the same when they were marked, identified and then introduced during the trial. This is because objection to documentary evidence must be made at the time it is formally offered and not earlier. 4. Cases prior to McCassery had similarly held that an objection to evidence must be made after the evidence is formally offered and that a documentary evidence is offered after all the witnesses of the party making the offer have testified. Contrary to the ruling of the appellate court, petitioners did not waive objection to admissibility of the said documents by their failure to object when these were marked, identified and then introduced during the trial. That was not the proper time to make the objection XXX. A document or any article for that matter, is not evidence when it is simply marked for identification, it must be formally offered. Candido v. Court of Appeals, 253 SCRA 78, People v. Santito Jr., 201 SCRA 87. It is when the accused fails to object to the admissibility of certain items during their formal offer, that he is deemed to have waived his right against their admissibility. People v. Diaz, 271 SCRA 504. How an offer of evidence is made. 1. When a party makes a formal offer of his evidence, he must state the nature or substance of the evidence, and the specific purpose for which the evidence is offered. Sec. 34 Rule 132, Rules of Court. Bar 1983. 2. The court shall consider the evidence solely for the purpose for which it is offered, not for any other purpose. Spouses Ragudo v. Fabella Estate Tenants Association, Inc., 466 SCRA 136. Objections, Purposes of Objections, Bar 2012. Objections may be made for any of the following purposes. A. To keep out inadmissible evidence that would cause harm to a client. The rules on evidence are not self-operating and, hence, must be invoked by way of an objection. B. To protect the record, i.e., to present the issue of inadmissibility of the offered evidence in a way that if the trial court rules erroneously, the error can be relied upon as a ground for a future appeal. C. To protect a witness from being embarrassed on the stand or from being harassed by the adverse counsel. D. To expose the adversary's unfair tactics like his consistently asking obviously leading questions. E. To give the trial court an opportunity to correct its own errors and, at the same time, warn the court that a ruling adverse to the objector may supply a reason to invoke a higher court's appellate jurisdiction. And F. To avoid a waiver of the inadmissibility of an otherwise inadmissible evidence. General and specific objections. Bar 1997. 1. An objection must point out the specific ground of the objection and, if it does not do so, no error is committed in overruling it. 75 Amur 2d, 2nd ed., section 254-256. 2. The last paragraph of Sec. 36, Rule 132, provides, the grounds for the objections must be specified. The objection, therefore, must be specific. Hence, an objector must be explicit as to the legal ground he invokes. He cannot simply manifest that he is interposing an objection. He has to precisely state the exclusionary rule that would justify his opposition to the proffered evidence. 3. The following examples are considered as general objections. A. Objection, the evidence is incompetent. B. Objection. Inadmissible. C. Objection, incompetent, irrelevant, and immaterial. D. Objection, improper. They are called general for an obvious reason. They do not clearly indicate to the judge the ground upon which the objections are predicated. They assign no grounds to the objection. A general objection, in including everything, actually specifies nothing. 4. An objection that evidences incompetent, irrelevant, or immaterial is ordinarily regarded in most jurisdictions, in the absence of any statutory provision to the contrary, as not sufficiently definite to present any question for review. Mills v. Texas Compensation Inns, Co., 75 Am. Ur. 29256, because it conveys neither to the court nor counsel any specific point of objection. 75 Am. Ur. 2d. 256. 5. Rule 132 does not tell us how specific an objection must be. Practical reasons, however, tell us that the objection must be specific enough to adequately inform the court the rule on evidence or of substantive law that authorizes the exclusion of the evidence. Objections like, question calls for a hearsay answer, witness cannot testify on a privilege, the question calls for a conclusion, communication, the question is beyond the scope of the direct examination, impeachment is improper, are specific enough for anyone to know the basis of the objection. 6. While an objection that the evidence is incompetent, irrelevant and immaterial is, by common wisdom, conceitedly a general objection, some writers hold that an objection that the evidence is irrelevant may, at times, not be general. This kind of objection states a distinct and substantial ground for exclusion. M. Graham, Handbook of Federal Evidence, 13 16, 1981. It is submitted that the opinion is worth considering. Necessarily, when the evidence clearly is one which does not prove a fact in issue, with no probative value and with no relationship to the fact in issue, or inadmissible for any purpose and no other objection is possible, there is no other ground for the objection except to say that it is irrelevant. In such a situation, this should be deemed as substantially the equivalent of a specific objection. 7. The rule is that a specific objection is always preferred over a general objection. This is not to say, however, that a general objection can never be allowed. The rule on specificity is dictated largely by the need to allow the court to intelligently rule on the objection and give the other party an opportunity to withdraw the evidence or correct an error in his presentation. The rule, however, does not impose a general or an absolute ban on general objections. There is no compelling need to specify the ground, if the ground for exclusion should have been obvious to the judge or to counsel. Floyd v. Hibbard, 227 Iowa 149, 287 NW 829. There are cases where the incompetency of the evidence is so palpable that a mere general objection is deemed sufficient, and where the portion of the evidence objected to is clearly pointed out and its illegality is apparent on its face, then the objection must be allowed. 75 Am. Ur. 257 citing Scott v. Times Mirror Co., 181 California 345 184, p. 672, 12 ALR 1007. Formal and substantive objections, Bar 1997. 1. Objections may be formal or substantive. A formal objection is one directed against the alleged defect in the formulation of the question. Examples: ambiguous questions, leading and misleading questions, repetitious questions, multiple questions, argumentative questions. 2. A substantive objection is one made and directed against the very nature of the evidence, i.e., it is inadmissible either because it is irrelevant or incompetent or both. Examples: parole, not the best evidence; hearsay, privileged communication, not authenticated; opinion, res inter alios acta. Objections must be timely. 1. Aside from the requirement that an objection must state the specific ground relied upon, it is also necessary that the objection be timely. When a party desires the court to reject the evidence offered, he must sustain in the form of objection. Without such objection, he cannot raise the question for the first time on appeal. See People v. Gabuya, CR number 195245, February 16, 2015. 2. In order to be timely, therefore, the objection must be made at the earliest opportunity. 88 CJS 236. What the earliest opportunity is depends upon the manner the evidence is offered. A. If the evidence is offered orally, objection to the evidence must be made immediately after the offer is made. Sec. 36, Par.1, Rule 132, Rules of Court. B. An objection to a question propounded in the course of the oral examination of the witness shall be made as soon as the grounds therefore shall become reasonably apparent. Sec. 36, Par.2, Rule 132, Rules of Court. c. An offer of evidence in writing shall be objected to within 3 days after notice of the offer unless a different period is allowed by the court. Sec. 36, par.3, Rule 132, Rules of Court. 3. The rules, therefore, make the offer of evidence the frame of reference for a timely objection. Hence, it is to be assumed that an objection to the evidence before it is offered is premature and no adverse inference may be had against a party who does not object to the evidence before it is offered. 4. Recall that the rule requires that an objection to a question in the course of an oral examination should be made as soon as the ground for the objection becomes apparent. Consider this example where the question is asked to prove the truth of the statement of an outside declarant. Mr. Santos, can you tell this court what Mr. Cruz told you about the truth of how the collision happened? Objection, Your Honor. Question calls for a hearsay answer. Sustained. By objecting as soon as the question was completed, counsel has succeeded in preventing the witness, Mr. Santos, from introducing a hearsay answer into the records of the case. The nature of the question manifestly required a hearsay answer, and so the ground for the objection became apparent as soon as the question was asked. In this situation, an objection made after the witness has answered would come too late. 5. There are witnesses who are quick to answer even before the question is over. Before the adverse counsel can react and object to the question, the answer comes in rapid-fire fashion, preventing counsel from inserting himself neatly between the question and the answer. What does counsel do in this case? Counsel must, nevertheless, object, state his reasons, and move to strike out the answer. This is a technique which the lawyer avails of when he does not have the opportunity to object before the witness responds. Should the witness persist in giving lightning-quick responses, counsel should request the judge to direct the witness to allow opposing counsel to object prior to his answer. The provisions of the rules of court are explicit. Should a witness answer the question before the adverse party had the opportunity to voice fully its objection to the same, and such objection is found to be meritorious, the court shall sustain the objection and order the answer given to be stricken off the record. Sec. 39 Rule 132, Rules of Court. Thank you. See you next slide.